Thank you very much. This is the time set for oral argument in City of Scottsdale versus State of Arizona, plus Jim Torgerson and Sign King LLC. Let's begin with introduction of counsel for the appellant.
Good morning, Your Honor. Scottsdale City Attorney Bruce Washburn on behalf of the appellant, and also with me at counsel table, Senior Assistant City Attorney Lori Davis.
Thank you very much.
Your Honor, David Wangswag on behalf of the state.
Good morning. Clint Bolick on behalf of the interveners, and with me, my colleague Jared Blanchard.
Great, very, very nice. Thank you all for being here today. Let me go through a few preliminaries. Each side, and I emphasize side, has 20 minutes. Let me advise the parties and their counsel that the court has read the briefs carefully. We've looked at pertinent portions of the record. We have conferenced the case and discussed it, so we are familiar with the issues and the arguments you have raised. We are recording the proceedings today, both video and audio, so when you go to the podium to speak, if you would please restate your name so whoever is listening by audio will understand who's speaking. Appellant may reserve time for rebuttal. If you do so, when you go to the podium, if you'll let us know how much time you would like for rebuttal, we will do our best to make sure we don't poach on your time and that you actually end up with that time. So I think with those preliminaries out of the way, we'll go ahead and begin.
Thank you, Your Honor. Bruce Washburn on behalf of the appellant, and I would like to reserve 5 minutes for rebuttal. The most important fact in this case, and one which I think has been largely ignored by the defendants, is that the citizens of Scottsdale own the sidewalks. They own the sidewalks just as much as they own City Hall, just as much as they own Scottsdale Stadium, spring training home of the world champion San Francisco Giants, and just as much as they own the police headquarters. And the city has to manage the property that the city owns. Why is this the most important fact in this case? It's because the question to be determined is whether the city is exercising a power as an agent of the state, and this is the test that's set forth by the Arizona Supreme Court in Lures, whether they're exercising a power as an agent of the state or whether they're exercising a power that is inherent to the management of the city and the city government. And clearly, the ability to manage one's own property is a power that has to be inherent in any government.
Are there any limits?
Go ahead.
Are there limits to your authority to control what happens on streets and sidewalks
Yes.
in Scottsdale? What
Yes.
are those limits?
Well, of course, there's constitutional limits. We're the government, and we have to act, as does everybody. This city has to act in accordance with the government. But as I'm going to discuss, if there's also a demonstrated statewide interest that is involved in the action that the city takes, then the decision has to be made, a judgment has to be made as to which is paramount, the city's interest, the power that it's exercising not as an agent of the state, or the statewide interest that has been demonstrated.
And isn't that the problem that we face?
I think it's the important issue in this case, and I think, as I'm prepared to discuss, I think the correct resolution is that the city's interest is paramount. The fact that the city controls its own property, and it has to be able to control its own property, is demonstrated by the fact, and it's not doing so as an agent of the state, is demonstrated by the fact that the state does not have the power to control the city's property. The state does not own the city's property. If the state wanted to put a DMV station in City Hall, it could not order the city to put the DMV station there.
The state can control conduct on state property. Certainly if people commit crimes on the streets or the sidewalks of the city of Scottsdale, the state does have an interest in controlling activity.
Yes.
So isn't that different than controlling the cases that talk about buying or selling or leasing property owned by the city? This seems very different. This is just controlling conduct on public property. Yes, the city has the right to control conduct on the city's property.
The state, if there is a demonstrated statewide interest, would also have the right to control that activity. But that's the question. Is there a demonstrated statewide interest involved in this matter? And I believe the answer to that question is no.
One of the problems I'm having is, having read a number of the cases, is trying to articulate a principled standard or test or analysis to determining what is in fact a statewide interest versus truly a local interest. And I think it's fair to say that our case law is a little vague on this point. So tell me, what do you suggest what factors should we consider in determining whether an interest is of statewide importance?
I think that the correct test is the one, again, that's stated in LURS. You look at whether the city is exercising the power that's at issue as an agent of the state, or whether it is exercising the power as inherent in the city's management of its own government. And clearly here, the city is exercising the power to control commercial activity on its own real estate as a part of the management of its own government. I don't think there's any question about that.
The problem I'm having, and forgive me, I guess I've had a lot of problems today, but the concern I have is, for example, speech. Speech occupies a special position, a position in under the First Amendment. Normally, cities or other forms of government cannot ban speech on public forums. So insofar as the legislature is saying this is speech, and it rises to a statewide importance because sidewalks are a public forum, we want to have uniformity throughout the state. That's pretty compelling. So how do I fit that into my factors if the only factor I look at is, well, this is something that Scottsdale is not acting as an agent of the state? If that's the only factor I look, how do I fit all that in?
By looking at whether or not, in fact, in this case, there truly is a demonstrated statewide interest. I think everyone agrees that the state cannot simply by fiat, by declaration, create a statewide interest, nor the fact that somebody might be able to hypothesize some statewide interest does not in and of itself show that there is a statewide interest in this case. So let's look at what the evidence is. Let me just back up for just a second. I'm going to proceed now, taking it as a given that the city has an interest in controlling its own property, the property that belongs to itself, and that the state does not get that power from the state. The state could not.
Well, doesn't the charter authority, doesn't it say it can exercise it consistent with the laws of the state?
Yes.
It's not unfettered authority to do whatever it wants.
Yes, that's absolutely right.
And so if the state legislature has come in and passed a law, and they've said the statewide interest may be uniformity, we want uniformity for all of our residents to not have to change what they're doing as they go from one city to another. And I'm sorry I interrupted you, but it seems to me it's not unfettered authority on the part of the city to ignore.
City's not claiming unfettered authority at all, but the state passed a law that said that all cities had to follow certain procedures in the sale of their real estate. Turns out that did not apply to charter cities. State passed a law that said the cities could not, because
Isn't
it was
that
a sale
different
of
in
their
that it
property.
only affects the taxpayers of Scottsdale? It doesn't necessarily affect people who are going through Scottsdale. A lot of people use the streets and sidewalks of Scottsdale who aren't residents, who may not have a financial interest necessarily in the property that your city owns. So doesn't that change the analysis a little bit?
It certainly figures into the analysis, but the state passed a law that said that you could not have background checks for the sale of firearms. And yet the courts found that because the city of Tucson and its convention center was requiring background checks in the use of its own property, that law did not apply. So the mere fact that the state passes a law and says this is a matter of statewide interest does not end the discussion. It just barely begins the discussion. So let's look at what does the evidence show in this case is really the statewide interest here. And I think the answer is it does not show any. I would recommend doing this analysis in the context of the City of Tucson versus state case, the one about consolidated elections. Because in that case...
The Supreme Court decision or the Court of Appeals from 2014?
I was referring to the Court of Appeals decision. Because in that case, the analysis, and I'm just talking about the type of analysis was done, in that case, the analysis was, all right, it's recognized that cities have an interest in their elections, just like it's recognized that cities have an interest in managing their own real estate. Otherwise, we wouldn't have the Alpha Sigma Epsilon case, we wouldn't have McMahon. It's recognized that the city has an interest. So let's look at what the state's interest is, and then we have to see which one is paramount. And in that case, the state showed that they had had like a 2-year study, trial study period to find out what was the impact of consolidated election laws. And they'd taken extensive testimony, and the court looked at what the testimony had been. And they determined that, in fact, the state's interest was paramount in that area where the city could also have an interest. We should do the same thing here. Look at whether the state has come in and shown that there's actually something that makes a difference to the state. And what have they got in this case? Well, they've got a state legislature that says, we think it's a statewide interest to have uniformity with respect to the use of the sidewalks. And yet they don't even require uniformity. They require that sign walkers be treated, as I said in my brief, more equal than the other people who they say they want to have treated equally. And there's not one fact to show why that would be important.
I'm not sure I read that in the statute. It seemed to me that it was just saying that you can't single out sign walkers and just enact an outright ban on sidewalkers.
It's saying that you can't impose reasonable time, place, and manner restrictions on sidewalkers, which you can impose on any other citizen using the sidewalks.
What language are you looking at that you're suggesting prevents them from prevents the city from reasonable time, place, and manner restrictions?
A municipality that adopts reasonable time, place, and manner regulations relating to sign walkers may not restrict a sign walker from using a public sidewalk, walkway, or pedestrian thoroughfare. That's
I'm reading
the
that
statute.
as it can't restrict. You can't just say sign walkers are absolutely prohibited. But that doesn't tell me that you can't put some sort of limitations on sign walkers.
Well,
just like you could on anyone.
Well, perhaps we could, but what we can't do is let me remind you that we already litigated the issue of whether the city's ordinance was a reasonable time, place, and manner restriction under the federal Constitution. And Judge Downey, who's then at the Superior Court, found that, in fact, it was a reasonable time, place, and manner restriction. What this says is that we could make that reasonable time, place, and manner restriction for any other citizen in the world, but we can't make it for sign walkers. So they're not requiring uniformity. They're requiring the sign walkers receive better treatment than others.
I'm not sure I've seen the issue litigated as to whether, for example, a sign spinner that's sticking out into the street, that you could have a restriction on that would somehow not be a permissible act on the part of the city.
Well, if it would restrict them from using the sidewalk, I would say that that's what the statute is trying to get at. But regardless of the efficacy of the statute and to what extent it places a restriction on the city, the fact of the matter is there's not one piece of evidence in this case that it makes any difference whatsoever whether there is uniformity across the state on how sign walkers are treated. But
If you were representing the state, let's put your advocate hat on, and you were representing the state, and you heard that argument, what is a piece of evidence that you would present to make the state's case? I mean, I understand they haven't presented it, but what would you present then?
I don't know, because I'm having trouble imagining what would be a reason why every sign walker would have to be treated the same in every city. We have numerous. I mean, this is a business regulation. It's in the city's business regulation section of its ordinances, and there are numerous different business regulations all across the state that the state has never found required uniformity. Some cities have regulations relating to pawn shops. Others don't. I mean, there's just a myriad examples of that. So I do not know what the argument would be for why these people need to be treated differently from every other type of business and from every other citizen using the sidewalk. But basically, regardless of whether or not the statute's a good idea or a bad idea, the fact is there's still not one fact that supports that there's some need for uniformity across the state. And then you have to remember that it's butting up against the fact that the city has under its charter the right to exercise its control over the
Doesn't the
city
state
sidewalks.
legislature do things all the time to try to encourage business in the state of Arizona to try to make it easier on businesses? Isn't that something they routinely talk about? Why wouldn't this be viewed as this would be something that would make things easier for us to attract businesses statewide, to have a consistent policy that we're not going to force people to do something different with regard to advertising from city to city?
Well, if the state had presented some evidence, or for that matter, if the state legislature had considered that fact and said, this is why we're doing this, but that's not what they say. If they'd said this is why we're doing it because it will encourage business, then we could litigate that issue. But that's not what's at issue here, because they didn't say that, and there's not one fact to support that. Just because somebody can conceive of some reason why this might be a good idea statewide does not mean that it proves that it's necessary statewide. The state has to have something they can point to when they are depriving the city of its ability to exercise its fundamental power to control its own property, something other than a hypothetical about why it might or might not be a good idea.
What's your best case for extending the case law that talks about controlling your own property, meaning buildings and something that you can sell or lease, compared to just public thoroughfares?
Well, of course, the Alpha Sigma Epsilon case regarding the sale of public property applied both to buildings and right-of-way and everything else. In fact, I think that was a right-of-way case. The argument is that the city of Scottsdale has to be able to control its right-of-way. And I don't think there's any question that that is a power that the city has not derived from the state, because the state doesn't have the power to control our right-of-way.
What's your argument? Sorry to interrupt.
Sure.
How do you distinguish the Coles case?
Coles is completely different from this case. Coles, the city never argued that it had the authority under its charter that its ordinance was authorized by the authority under its charter. That was a case where there was a very narrow difference, and the city argued successfully in the Superior Court and unsuccessfully on appeal, between the city's ordinance and the state's ordinance, so they did not conflict. Once it was determined they conflicted, the city, of course, acquiesced, and the case was over with. The other thing about Coles is it had nothing to do with city property.
It was conduct on public streets.
Conduct in public. And in public is not just city property. In public is if you're...
Wouldn't the city be arguing, we're just trying to make our streets and sidewalks, it involves public drunkenness. We want to keep our streets and sidewalks safe. So you're suggesting that if the city had simply made that argument, Coles would have turned out differently, that it's part of our charter authority? We
would not have made that argument, because Coles, the ordinance in Coles didn't apply just to city property. It applied to any drunkenness anywhere in public. I mean, that was argued by my office. I'm very, very familiar with the approach that was taken in that case, and charter authority was never an issue, because clearly we don't have charter authority in that case for any place that somebody might be falling down drunk in public.
I guess a follow-up question, why does the state have a statewide interest in controlling public drunkenness in Scottsdale?
Well, the issue of intoxication has already been litigated. That was done in the context of drunken driving, and the courts have found that there is a statewide interest. So, I mean, that issue's been decided. I don't know if I were there and went back and relitigated that issue, maybe I would advocate for a different outcome. But that's already been decided. We don't have an issue with that. I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you.
May it please the court, David Weinsweig on behalf of the state. Before I start, the state has agreed to split its time with Mr. Olick of the Goldwater Institute. I understand that's not your problem, it's mine, but...
Talk quickly.
If I can start where you ended, because this appeal turns on one uncontested fact. The city of Scottsdale seeks to criminalize that which the state of Arizona expressly permits. That is the beginning and end of the analysis. The Scottsdale ordinance is per se invalid because neither charter cities or general law cities can define criminal offenses that conflict with state statutes. That's what the seminal treatise on municipal law says, McQuillan. That's what this court has said, most recently in 2004 in the Coles opinion, and as long ago as 1979 in the Baumert opinion. The seminal treatise on municipal law at chapter 23:7, citing to the state of Arizona and the Baumert decision as reflecting what is the national law, states, and I quote, any municipal control or prescribing of criminal offenses must conform to and not conflict with the Constitution, statutes, and public policy of the state. That is what this court has twice recognized as a bedrock principle. Coles, as was just referenced, was not different than what we have today. There, the city of Scottsdale wanted to get what it wanted, in that instance, public drunks off its street, citing, if I can, and this is the brief before this court, citing the quote, and this is at page 26 of Scottsdale's brief in Coles, citing the quote, uniquely proper and basic local police function in Coles, and effectively making, not effectively, hoping to evade what were conflicting state statutes on that basis. Now, the court rejected and found invalid the ordinance in that case because it conflicted with state law. Same exact thing happened 35 years ago in Baumert, where this court invalidated a City of Phoenix ordinance that defined an offense for indecent exposure. And there, the offense in the Phoenix City Code was different than that in the state code. And so this court held the ordinance was invalid. It didn't even reach a preemption analysis.
Can I interrupt? And I'm curious your reading of the state statute about whether it would prohibit some sort of reasonable time, place, and manner restrictions on sign walkers.
Your Honor, my understanding is the statute allows time, place, and manner restrictions on sign walkers, just as and to the same extent such restrictions are placed upon all other people. So if you look at there's a statutory intent sort of provision. Section 2, it's not actually part of the what's in the books, but it says fairly clearly, although I have to go from memory, that the purpose of this is a matter of equal treatment and nothing more. And that is the cities must treat a Girl Scout with a sign advertising for a car wash, a sign walker advertising a sale at Walmart, and Joe and Susan, who might be walking down that very street, the same. So a time, place, and manner restriction is perfectly kosher. It just has to be equally applied.
So is the test for what is of statewide importance here basically whether the charter ordinance criminalizes conduct that the state has otherwise authorized, or at least not criminalized? Is that the dispositive factor?
it is a dispositive factor in that I don't think you even reach that question of statewide versus local.
Let's assume for the moment we didn't have that problem, because I'm still struggling with the case law here. What factors should we consider?
Well, Your Honor, I can say I agree with my good friend from Scottsdale on the case that governs, and that is lures. But I want to draw the court's attention to a specific paragraph or sentence in lures that explains what is a statewide interest and what is not. And the quote is from lures, "We think the preservation of order and the protection of life and property and the suppression of crime are primary functions of the state, that the entire state is interested in these matters, and that they are proper subjects for general laws." And I must take some blame here in that the briefing really didn't make this point as clear as it needed to be made. And the point is, everything and every reason the city of Scottsdale has offered today as its rationale for criminalizing streetwalkers falls under the banner of police powers. And police powers are delegated from the state and must be, in case after case, many of which include the city of Scottsdale as the defendant. Arizona courts have said when powers are delegated, they must be exercised as applied or not at all. So in this case, whether the Enabling Act is the sign statute that the city is insistent on saying is zoning, so it doesn't matter, or another enabling statute like 9-276A, which just is a delegation from the state to charter cities of the power to regulate streets and sidewalks. So I think we've sort of covered now in a game of Enabling Act cat and mouse the potential escape routes. Whichever way the court turns, it will find an Enabling Act that is conferring the very power used to criminalize sign walkers and a general police power as recognized in those cases. If I can also make one point. At the beginning of counsel's remarks, the question counsel framed the question as whether the city's interest is paramount, and that's the word he used, paramount. But that's hardly the test. The test actually has an adverb, and not a meaningless adverb. It has purely or strictly local interest. So
in your view, are there areas other than the sale or purchase of real estate and the control of local elections that would be strictly within the purview of the city?
Those are the two areas that have been recognized, and I think for good reason. I could brainstorm and maybe come up with some others that sort of carry that rationale forward, and the rationale being, in the commercial context, you have a singular transaction in which people are entering into, or in this case, the city is either leasing or selling its real property, and the impact or ripple effect of that transaction goes no further than the boundaries of the city. In this case, I was trying to think myself, how would this case fall under McMahon? And I sort of, it came to me late at night, and it would be something like this. If the city of Scottsdale wanted to lease or provide a use agreement to Walmart to use the Scottsdale Stadium. And they had a contract that said, here's the document that you need to sign, the effective lease agreement for us to convey our real property interest. And by the way, there's a provision in that singular contract that says no sign walkers from Walmart can be walking outside the stadium, even if they're pointing people in the direction of traffic or otherwise. That's McMahon. This case, where you have a permanent, perpetual ban, criminal ban on sidewalkers in every corner, on every street, and every sidewalk in the city, unrelated to the conveyance of any particular property interest, is not McMahon. Now, I see I have 8 minutes left, and if I could tag my partner here.
Thank you.
Thank you.
May it please the court, I am Clint Bolick, representing the interveners, Jim Torgerson and Sign King. 3 primary points to make. First, the decision of whether the state can prevent Scottsdale from creating a free speech free zone, which it has done here, and I should say, not just for sign walkers. When you look at the majestic breadth of this language, it sweeps in so many things with have, bear, wear, or carry, brings in car wash signs and signs for garage sales and so forth. The decision about whether the state can forbid Scottsdale from doing that was made over 100 years ago, when this state made it a part of its organic law to protect freedom of speech, particularly, as Scottsdale concedes, on public streets. And so that is what establishes the statewide interest, and that is the interest that the legislature clearly was attempting to promote here. And free speech should not, must not vary depending on whether you're on the street of Scottsdale or on the other side of the Phoenix border.
Do you agree, Mr. Bullock, then, that under the statute, the city can at least enact reasonable time, place, and manner regulations?
Judge Norris, that was going to be my second point. And
I read your mind, okay.
Yes, that's a scary thing.
Oh, I know.
Absolutely it can. The only language that Scottsdale is attaching itself to are from the legislative findings relating to equal treatment and so forth, but the plain language of the statute itself expressly reserves the power to regulate for time, place, or manner. It's exactly as Judge Catani was suggesting a few moments ago. You simply can't eviscerate it altogether. And as our Supreme Court recognized only a short time ago in the Bowler case, an outright ban on the public streets is the worst, the most offensive type of free speech violation. So the question with regard to the free speech aspect, it appeared that Scottsdale was making a very remarkable and unique argument in its brief, and that is that only the courts can protect free speech rights. And every public official in this state takes an oath to defend and uphold the Constitution. So if the legislature is codifying, if it is consistent with the free speech rights of our Constitution, unquestionably it is promoting a statewide interest. The other point that I was going to make, Judge Norris, it would be extremely helpful were the court to articulate a really good test for what constitutes a statewide interest. I do believe this court has brought 1 year and 1 week ago a great deal of harmony to the cacophony in this area in the State versus Coles decision, which at least set forth the framework for deciding that. But I don't think that the court needs to necessarily decide that question today, because there is one bright line rule with regard to statewide interest, and it is the rule that my colleague, Mr. Weinsweig, articulated, and that is the police power. And the Coles decision was the heir to a much earlier decision, Clayton versus State, going back to 1931, which dealt with DUIs specifically. And Mr. Washburn said a few moments ago, well, we were regulating all public spaces, but the city's articulation of its interest in that decision in Clayton, which involved DUIs, the city was arguing we're simply regulating our streets. The state does not have an interest in doing so. And the court could not have been more categorical at 38 Arizona, page 145, when it said, and I quote, "The police power inheres in the state and not in the municipalities. There is no case of which I am aware in which the state is exercising its police power, which sweeps in the regulation of public health and safety, in which a city's interests were found to remove the ability of the state to regulate." And you see that in State versus Coles and all of the other decisions, including Levitt's, which is probably the case that's most on point with this case. The entire issue of sign regulation, there was no sign regulations that have been struck down as within the city's purview. Levitt's, in one of the Scottsdale cases, placed that the whole argument about whether it's zoning or not is beside the point. Zoning is part of the police power. And so the regulation of signs on public streets, just like the regulation of intoxication on the public streets, is an exercise of the police power. So here you have not one statewide interest, but two, either of which is independently sufficient to uphold the ability of the state to bring uniformity to what happens in this state, and that is that sign spinners and the myriad other people who fit within the scope of this ordinance may not be prevented, may not be excluded from the streets in displaying speech. Thank you.
Well, you have 1 minute and 59 seconds. Would you like to finish it up?
I appreciate the invitation, but unless the court has questions, I don't need to fill its time artificially.
Okay. Mr. Washburn?
Thank you, Your Honor.
I feel the defendant's pain in trying to find a rationale for their position in this case. This is so interesting because we argued this case in front of the Superior Court, and at that time the statement was made that this is a zoning case, and that finishes it. There's no more analysis. This is a zoning case. These are signs. They're zoning signs. This case is over with. Now we find out that no, this is a police powers case. This isn't a zoning case. And because this is an exercise of the police power, this case is over with, and there's no further analysis needed. Well, there's several problems with that. One is they are asking this court to adopt a radical new test that does not exist anywhere. You know, they've been looking for a rationale for this case, and that's why they said Coles was indistinguishable, even though Coles is not a charter city case, and why they've taken now the case that they apparently, the 1979 case that they just discovered yesterday, Baumert, as being the controlling case here. And I'll talk about Baumert in just a second. But here's why you should not adopt this radical new test, which says that, as I understand it, if you're going to arrest somebody, then it has to be a matter of statewide concern. I don't think any court has ever said that. And that's because it's not, whether or not you arrest somebody is not the touchstone of whether or not you're exercising the police power. The police power is the power that's exercised for the good of all of the citizens. But it doesn't mean that that every time you do something for the good of the citizens, you're exercising the police power. But
isn't there a statewide interest in having uniform, having the citizens of Arizona know whether they're going to be arrested from one city to the next?
Many cities have different criminal ordinances, and the state permits them. So the state obviously does not believe for a second that there's a need for uniformity in criminal ordinances from one city to the next. There's things that are illegal in one city and not in another all over the state.
And where you're criminalizing what some would argue is free speech, isn't there a statewide interest in saying we'd like consistency throughout the state and people knowing whether they can be prosecuted for for free speech differently in Tempe than in Scottsdale or Mesa?
The city already litigated the issue of whether or not this was free speech as guaranteed by the Constitution, by the United States Constitution, and won that case.
But that was before there was an ordinance, and if the legislature comes in and says this is something that we view to be important, why can't the legislature speak on that issue?
Because the courts have held that the mere fact that the legislature says this is an important matter of statewide concern does not end the analysis.
I understand that, but it seems to me it also doesn't end the analysis that there was a case that said it's not guaranteed by the federal Constitution. The state legislature comes in and says this is something that that's important to us as a state. I don't think that previous case necessarily is dispositive.
I would argue that they still need to be able to point to some fact that establishes that it is important to the state, that it makes some difference. You know, they talk about, oh, well, this will put people out of business. There's ample opportunity for people to do sign walkers on private property or in parking lots. Let me just make one point about Baumert, if I could, please. I appreciate the state having come across the Baumert case because it makes my point. If you look at Baumert, what they said in that case was that there is this conflicting statute and a conflicting ordinance, and the statute controls over the ordinance. Fine, absolutely no problem, because it was a matter of statewide concern what they were regulating, just like public intoxication is a matter of statewide concern. That's already been litigated. The city doesn't argue that. But then they went one step further, and the only time they mentioned the city of Phoenix's charter in the Baumert case is when they said, oh, look, Phoenix, you criminalized one thing that the state did not criminalize, and you can do that because that power is in your charter. In other words, the Baumert case establishes that the city can take power from its charter to criminalize a matter and not have that power derived from a delegation from the state. The Baumert case proves that the one point that they said here today is absolutely crucial, is dead wrong. Cities do have the power under their charter to criminalize behavior. Thank you.
Thank you very much for your argument today. We appreciate your briefing and your argument. No. We're going to adjourn and take this matter under advisement. Thank you.